All right, let's go ahead and proceed.
Thank you, Your Honor. I just got a pop-up here on the screen. I'm trying to close it out. There it goes. I represent White Settlement Senior Living. As you may recall, Your Honor, you executed an order on June 24th, 2022, confirming a final arbitration award issued by the retired Honorable Judge Whittington. And we are now before you in connection with that and the effort to confirm the award and also beat back challenges that were, filed in a series of materials seeking the reimbursement of the additional attorney's fees that have been incurred since the final award. It's roughly $73,000, plus we're seeking cost, expenses, and disbursements of about $4,100. I should say as part of that, as part of that $73,000, there's about a couple $1,000s incurred by on my former co-counsel, Randall Schaefer. Mr. Schaefer has unfortunately passed away. He's not here, but the materials that we submitted are in the record by way of affidavit, and we would just respectfully suggest that the affidavits we provided can be received in lieu of testimony. Of course, if the other side feels they need to cross-examine, that would be fine. I'm here to answer all those questions. But there's a couple of reasons I want to offer for why we believe you have the authority and should award the relief we're requesting. But I also want to reserve a little bit of time to talk about the opposition that was received last Wednesday and the proposed order that they have provided in connection with that opposition, because it goes way beyond what you would otherwise expect if you were going to deny our motion. And I'll come back to that and explain that to you at the end, because it's quite concerning. But in any event, under the parties' contracts, if there's a finding that the party acted without substantial justification, the arbitrator had authority to enter an award of attorney's fees in the proceeding. So there's a question presented to you as to whether or not this proceeding is an extension of that proceeding or not. We would respectfully suggest that it is, because it was an order to confirm the arbitration award and everything generates and flows therefrom. So we believe there's authority there. We also believe that because Texas law is governing this particular dispute pursuant to section 17.1 of the parties' agreement, that you can rely on case law that also allows for the award of attorney's fees. We had provided our initial motion papers about 7 weeks before we received their opposition on Wednesday. So the opposition came in, and I would just respectfully like to say that we didn't have an opportunity to put in a reply brief given the amount of time that we did not have to do so. But there's a very important case that I'd like to direct your attention to, Your Honor, and that's Stage Shores, Inc. v. Gunnarsson. And that's at 477 Southwest 3rd, 848, Texas Appellate House, 1st District, 2015. And more specifically at pages 863 to 864, you'll see that the court there, citing 5th District case law, determined that when a party's challenge to an arbitration award is without merit and its refusal to abide by the award is without justification, a trial court can award attorney's fees to the party seeking to confirm the arbitration award. That's a quote. That's authority on which we are relying. They certainly have cited you to some authority that goes the other way, but that authority is inapposite here. We have a finding from the arbitrator that they acted without substantial justification in causing Mr. Mitchell to incur over $450,000 of attorney's fees initially in the proceeding. And then afterwards, this is an arbitration, for goodness sakes. I mean, it ought to have been confirmed and everybody can go home. But now we've incurred another $73,000 in fees because they just kept fighting. And all the arguments that they were making in their motion opposing confirmation of the award and seeking that the award be vacated were the same arguments that Judge Whittington found were being made without substantial justification. So there's complete unanimity there in terms of their lack of merit and their lack of substantial justification, which we believe the Stage Shores v. Gunnarsson case supports and allows you to issue an award of attorney's fees and costs accordingly. Additionally, without belaboring the point, The Texas Uniform Declaratory Judgment Act allows for, in any proceeding under the chapter, a court may award costs and reasonable and necessary attorney's fees that are equitable and just. And Your Honor, as I'm sure you know, has broad authority there, and the provision is to be liberally construed and administered. We also believe that Chapter 38 of the Texas Civil Practice and Remedies Code applies. So for those reasons, Your Honor, I would just respectfully request that you receive the attorney's fees and costs by way of affidavit and issue the relief we requested. Now, if you're inclined not to do so, I would urge the court to proceed with caution when it looks at the proposed order that was offered by the defendant in this matter. They are asking you to undo relief that you yourself already awarded when you confirmed the award. On June 24th, 2022, you signed this order confirming the award. We were there in your courtroom. You may recall, you've had a lot of things happen since, but it was a very memorable day because you had a wedding and a birthday for one of the law clerks. So we all sang happy birthday and we all got the opportunity to see this wedding. So you confirmed the award that day and you asked opposing counsel any objections to this proposed order, and they said none, and you signed it. And as part of that, you confirmed the award. They are now asking you to deny our motion, and the first thing they asked you to do is confirm the final award. You've already done it. Doesn't seem like a problem, but then they go on to say that there's going to be a stay, and that stay is going to apparently retroactively take away from relief you granted us that day, because in paragraph 2 of your order, you said that the limited partner interest that we've been fighting about shall be judicially transferred to my client. So then you went on and entered judgment, and you said that the interests are hereby assigned, transferred without the need for further order of the court or execution of any document to the parties. You judicially transferred those limited partner interests to us on June 24th, 2022. And asking you to deny our motion, they are asking you to stay execution of the judgment. They are asking you to, upon the lifting of the stay that you're supposedly going to enter, if you deny our motion, that they're going to stay the transfer of the limited partner interests that have already been transferred. So it's very troubling in that sense. In addition, I think they're trying to
let's deal with the order once we get through with how I'm going to rule. So,
right.
response.
Thank you.
Your Honor, I'll address the attorney's fees motion. I'm not familiar with the case that Mr. Davenport cited, but he did say that it was not from the 5th District in Dallas. We cited the, excuse me, we cited the court to the Crossmark case, which was decided by the Dallas Court of Appeals in 2004, and the 3 cases that it has been cited since, all of which hold that the enforcement, the confirmation and enforcement of the arbitration award is a separate action. And unless the arbitration agreement provides for attorney's fees in the enforcement confirmation, they are not available for award by this court. And there's no case to the contrary out of Dallas. The fact that there may have been, excuse me, the fact that there may have been the ability to award them because it was something that the arbitrator found was unmerited is completely contrary to what the Court of Appeals in Dallas said in Acra versus Bonato, which is quoted on page 6 of our objection. Namely, if I may read for a moment, in their 5th issue, appellants contend the trial court erred by awarding appellees their attorney's fees for defending against appellants' challenge to the confirmation of the arbitration award. The trial court stated in the final judgment, the court finds that respondents filed a motion to vacate the arbitration award, excuse me, without justification or merit. Accordingly, plaintiffs are awarded their reasonable attorney's fee of $16,000 for responding to and obtaining the denial of the motion to vacate and obtaining confirmation of the arbitration award. If an arbitration award includes an award of attorney's fees, a trial court may not award additional attorney's fees for enforcing or appealing the confirmation of the award unless the arbitration agreement provides otherwise. Mr. Davenport has not cited anything in the limited partnership agreement, which contains the arbitration agreement, which calls for or allows this court to award attorney's fees for the confirmation and enforcement. And there is nothing in the agreement which allows that. Mr. Davenport has also pointed to the, excuse me, to the Uniform Declaratory Justice Act. But I would quote from Malley versus Law Office of Daniel W. Lowe, a 2002 decision of the Court of Appeals in Dallas, which says you can't do it. Further, even if an award of attorney's fees would be proper in an underlying action, an action to enforce an arbitration award gives rise to a new and different cause of action for which there is no statutory basis for recovery of attorney's fees. Attorney's fees incurred in the enforcement of an arbitration award cannot be recovered by characterizing the suit as one for breach of contract or declaratory judgment. So that, by the way, was cited again with approval by the court in Dallas in the Quinn case. So in those 6 cases, Your Honor, the Court of Appeals in Dallas has made it very clear that this court does not have the authority to award attorney's fees.
So, Mr. Davenport, there's a saying that one of my favorite mediators when I was in private practice said to me when I was a young lawyer, and I kind of try to live my life by, which is pigs get fat, hogs get slaughtered here. I'm not going to award attorney's fees at this point, or I'm not going to award attorney's fees, additional attorney's fees. I'd urge you in the future, if you have a case in my court like this, I think he has every right to attempt to vacate it and appeal it. And, you know, that's his right. That's the way the process works. So to try to get additional attorney's fees, I think is kind of excessive. That being said, I looked at the order as well. I think it's way too broad. Why don't you guys prepare an order that says the following: one, that this hearing was heard on September 19th, 2022, and as opposed to on this date. I want Mr. Davenport, you to draft it. I wanted to say very simply that the request for additional attorney's fees is denied, and it doesn't need to go into anything else. We already have a final judgment, right? We've already approved this. There's no need for additional orders as far as I know, other than that.
Your Honor, the reason that we prepared the order the way we did was that we received a letter from the Court of Appeals dated August 9th, in which the appealed order here confirms an arbitration award and dismisses appellant's claim against appellee, but recites the trial court is retaining jurisdiction to determine any motion filed by appellee for attorney's fees and costs incurred since the arbitration award. Accordingly, it does not appear to be final. We did not object to that. We haven't received the dismissal yet from the Court of Appeals, but we're going to.
Wait, say that again, Mr. Davenport. Explain this to me. Did the original order, was it defective? Was that the issue, according to the Court of Appeals?
Yes, Your Honor. I would agree with Mr. Blay in the sense that the court was concerned that it may not be a final judgment. So we probably need just one additional comment that this is final. There's nothing remaining, and
go ahead and do it at what you need to do to correct whatever deficiency the Court of Appeals pointed out in the final judgment. This should be final. I'm not going to award any additional attorney's fees or costs at this point. And share that order with Mr. Blay. Mr. Blay will have 4 working hours to make any comments. I'd like a copy of that order in my office no later than Friday morning.
Thank you, Your Honor.
All right, guys, anything else?
Let me raise one question, and that was in your June 24th order, you required that there be a security posted before anything more was done. And that was done. That was, the funds were deposited with the clerk of the court on July 22nd. And we believe that stays everything. Now, there is the issue as to the language in the June 24th judgment order, which said everything is transferred. But we believe that under the circumstances, given that this is something which did not require further action of the parties, and the fact that Your Honor's June 24th order was not a final judgment, that the posting of the security should stay the transfer of the interests. And that's why we wrote it, the proposed order, the way it is.
Just want to be sure.
Are you saying we included a supersedious bond requirement? I'm not sure what you're talking about.
Yes, Your Honor.
Yes.
Let me just find it here.
Mr. Davenport, do you know what he's talking about?
I do, Your Honor. I think he's trying to unwind the relief that you granted on June 24th when you judicially transferred without any further requirement, the limited partner interest transferred to my client. That ship has sailed. That has happened. And I think they're trying to unwind it. You also included in that judgment a requirement that if they were going to do anything else relative to this arbitration, such as an appeal, they were going to have to post a bond. And that bond was posted based upon the then anticipated damages to be incurred. And they did post that bond, but the posting of that bond does not retroactively operate to secure back for them what you already transferred away from them on June 24th. That's over. They didn't move to reconsider. They didn't do anything. All they've done is challenge this motion, which was their right, and they've won, but they haven't offered you any justification for going back and unwinding the relief.
The bond I granted, was it a supersedious bond? Is that the deal?
Your Honor, paragraph 3 of your order says, the court further finds, to the extent defendant takes any further action with respect to this order and judgment, including any appeal thereof, defendant must first post security in the amount of $946,000, which was done.
I mean, I think the issue is, does that stay for you further execution of this order? I don't know if this is the appropriate way to do it. We're really trying to talk about attorney's fees at this point. I think if you want to further challenge that, Mr. Blay, on whether or not, I'm trying to think of the sequencing here. I ordered the transfer to occur. You've apparently stayed this according to a supersedious bond, as I assume, and that would stay the requirement to comply with the judgment that's how I understand it. And so I think this particular motion is dealing with whether or not additional attorney fees can be recovered by Mr. Davenport's client, and I don't want to try to mix the two here. So if you feel that there needs to be a stay issued as to enforcement of the judgment, I think that's something that you can bring up either with me or the Court of Appeals.
Okay.
All right, guys. Anything else?
No, Your Honor. Thank you.
Thank
Thank
you.
you. All right, guys. You have a good day.
You too.
Thank you, Judge.
Thank you.
Thank you, guys.
Yes, sir. Thank you.
Are both sides here on CADJ Irwin Farms?
Good afternoon, Your Honor. Steve Tittle for plaintiff respondent, and I see that Movin is also here.
Yes, Your Honor, Leal Slifer here on behalf of the movement, Megatel Homes, Aaron Ipor, and Zach Ipor.
So there's someone else coming in. Are we waiting on some other people? There looks like somebody named Megatel Homes is joining too.
Yes, my client is going to be watching, Your Honor.
I don't mind waiting. If you guys are ready to start, we can start. I kind of have already read everything and know what I'm going to do. So
we can go ahead and start, Your Honor. Thank you.
all right, so let's go on the record at this point on cause number DC 222108. Tony, you there?
Yes, Judge.
CADG Irwin Farms LLC versus Megatel Homes 3 LLC. Counsel, make your appearances.
Leal Slifer on behalf of Megatel Homes, Aaron Ipor, and Zach Ipor.
Steve Tittle and Brian Norman for all of plaintiffs' respondents to this motion.
All right, I've taken a look at all this. What a What an interesting procedural conundrum you have here. But I'm going to just kind of tell you what I plan on doing, and then if you guys want to comment on it or discuss it, we can. I don't think plea abatement is the correct remedy. What I'd encourage you to do, this is not an order, is one court should be, I think, probably handling all these cases, and it probably shouldn't be mine. Whatever the first filed case is, if there's a number of related cases, the first filed judge should be handling them if they're all related. If they're not related, then there's no reason for an abatement. So,
Your Honor, if I may, there are sort of two issues here. The first is that there are lots of underlying lawsuits in various courts.
correct?
Right. And so then the other issue is that there has been a claim by the plaintiffs here related to all of those various lawsuits in various courts here. And so I understand, Your Honor, that this is sort of maybe plea and abatement isn't the right procedural vehicle here, but I'm not quite sure. And we have another hearing on this on Friday, Your Honor, where the plaintiffs moved to transfer all the cases to one court. Actually,
Is that in my court or another court?
it's in your court.
It should
Your
not
Honor.
be in my court. I'm the last filed case. It should go to the first filed case. So
Well,
I'll just to kind of, because I don't want to waste your time. What I'll tell you on Friday is what I'm telling you right now, which is I'm not the right judge to make that decision. If the first filed judge or some judge ahead of me, I'm fourth in line here, so, or fifth in line, I think. I'm not the judge that should be deciding this. The judge that's first in line, and I've been the first in line judge on many, many prior occasions, and so I get how this works, and it's sometimes kind of frustrating, but it's not my decision to make. So I'm going to leave it up to the first file judge or whoever you guys decide you want to bring this in front of, not me. I'm clearly not the right judge to make this decision.
the one thing I will say, Your Honor, is that I'm not sure there's one judge, right? Because there are various different properties, and there's a statute that says that a claim related to a property has to be brought in the county that the property is located in. And that's why we have cases in Denton County, in Collin County, and Dallas County. And so we actually would ask Your Honor to just have the judges in the various counties that these properties relate to, send it to them to decide what to do. None of these should be in front of Your Honor. They should all go to the
Let me, I'm not communicating this very well, I don't think, which is I'm not the first file judge. There are other judges in Dallas County that can make the determination of whether or not this should be transferred to them. They can also confer with the other judges in other counties to make a determination. If this is truly related, and I'm not 100% sure it is, but if this truly is related, I am the last judge. I am the default judge. If all the other judges say this isn't related, then I'm going to go forward with my case. I'm not going to abate it. I'm going to leave it up to you to do that, though. It's going to be, I've just been down this road before. I'm going to move my case. And if another judge feels like it's related and takes it from me, that's fine. But I'm going to assume that unless another judge takes it from me, this is a case that needs to go forward, and I'm going to go forward with it. Does that make sense? And I would encourage you not to have the hearing on Friday, because I'm going to tell you that exact same thing, which is it's not my decision. It's the first file judge's decision.
Your Honor, plaintiffs will coordinate with the 160th as well as opposing counsel to seek to have that hearing for the motion to transfer heard in the 160th.
And I want to make it 100% clear. I do not say this case is related. I'm not telling the 160 if they should take it or they shouldn't take it. That's their choice. That's their judicial power or decision making to do. All I'm saying, it's clearly not mine. And so if they decide that it's related, they want to take it, I have no opposition. If they say it's not related, I'm happy to keep the case and move it forward.
Your Honor, I have a question for you. Should we then, because the relief we're seeking is to split up the cases into the various counties. Should that be heard in front of the 160th before they take it, or
They should, that's up to the one. Let me just say this. that decision should be decided by the 160th first. If the 160th says, no, this isn't a related case, Judge Hoffman should continue with it, and you want to file some motion for me to talk to, I'm not sure how you exactly do this, but once it's determined that my case is going to stay in this court, then we can kind of address those issues.
Okay, thank you, Your Honor. I think that is clear.
It's very clear. Thank you, Your Honor.
All right, can you guys, I don't even know, well, I guess just give me an order to deny the plea and abatement. Have you guys already submitted that, Mr. Tittle?
Yes, we have.
Let me just make sure I have it. When did you submit it? There it is. I see it. I will go ahead and print that out, and it should be scanned by tomorrow.
Okay, thank you.
Thank you, Your Honor.
Thank you, guys. You have a great rest of your day.
You too.
Thanks. Bye. Tony, Rhonda, are you there?
I'm here.
So it looks like our next hearing is not until 3:30, I believe.
That's what I show. So just come back and.
And I don't anticipate we're gonna, let me just double check this 4 o'clock hearing. I may not need I guess just sign on for the 4 o'clock in case we need you.
Okay, I showed a 3:30 as a special exception.
Yeah, you should show up for that just in case.
Okay.
Um,
All right, I'll
I'm
see
just
you.
trying to figure out if the 4 o'clock, we may or may not need you for the 4 o'clock, but we'll just kind of figure it out.
Okay, sounds
All
good.
right, I'll see you in 30 minutes.
Okay, Judge, bye.
Right.